David, this is like not the best news in the world that your property can be taken legally and apparently under our Constitution and everything. But I am glad for people who listen to this and now understand the process and know that they do have rights in all of this. They shouldn't just take what's in the packet necessarily. Hi there, and welcome back to Life is Legal, where we unpack the laws that sneak into everyday life without the Latin, the lecture, or the stodgy lawyer vibe. I'm your host, Brooke Hardy, lawyer, legal translator, and aggressively fast walker. Today's guest is someone I've known and admired for a long time. And he's someone who has made an entire career out of fighting for the underdog. David Todd has been a trial lawyer for almost 30 years, and these days he spends his time taking on governments and big companies in eminent domain cases, which is a fancy way of saying he stands up for landowners and business owners when their land is threatened. Now, on paper, David sounds very intimidating. And to be fair, he is a tall, dapper, and truly skilled trial lawyer. But truth be told, his phone's camera roll is filled with photos of not his wife and kids, but his two small poodle mixes, okay? Doing cute things and wearing clothes appropriate for the season, which tells you pretty much everything you need to know about David. David and I go way back, and I'm so excited to have him here today to talk about the ins and outs of eminent domain. David, welcome to Life is Legal.
Thank you. It's good to be here.
So I thought that if I pay my property taxes and I handle my mortgage every month, that I can pretty much be guaranteed to keep owning my own house. But you're here to tell me something different.
Yeah, that's most of the time that's true. However, if the government, as we say, or a company that gets to use the power of the government has a need for your property, whether it's your house or your raw land or your commercial space or whatever it may be, your real estate ownership, if they need it for a public project, and we can get into a little bit of what is that exactly, there is such a thing as the power of eminent domain. And they can use that to take your property for this public project. The catch to that is that going way, way back to Roman tradition and British common law and a lot of interesting things that most people probably don't want to hear too much about, but also included in the U.S. Constitution and the Texas Constitution, you have to be paid compensation for what is done to your property, what is taken, what is damaged, what happens to the value of the property that you have left over when the whole thing is over with. So that is when you're on the landowner side in eminent domain, which I am, that's what you're mostly concerned with is what is proper compensation, because in the vast majority of cases, it's hard to almost impossible to stop them taking your property under eminent domain. There are very select circumstances where you might have a shot at that, but they're very rare.
Well, you started right where I like to start, which is this law that we're talking about. Where does it come from? How is this law legal, in other words? And I, in doing a little research for this episode, I was pretty surprised, as I usually am when I do research, that, our U.S. Constitution, you mentioned the U.S. Constitution and the Texas Constitution, in black and white print, which is not always the case, Fifth Amendment of the U.S. Constitution, which everybody thinks of as I plead the Fifth. I don't have to be a witness against a crime I may have committed. I don't have to help the prosecution, Miranda rights, all of that. It's almost like a rider tagged on just to the very end of the Fifth Amendment, and it says, "Nor shall private property be taken for public use without just compensation. And so there's no question that this is legal. So to your point, you shouldn't spend, or you're not going to spend a whole lot of time arguing whether they can do it. It's just, okay, this is happening. So how do I sort of mitigate things and get the most value for what they're taking from me? Is that about right?
Yeah. That is right. And one example I like to tell clients sometimes if they're not quite getting it, there was a few years back, there was a huge oil and gas pipeline project through the Texas Hill Country, some really pristine areas, and Gillespie County and Fredericksburg and sort of around those areas. And it went on for years, and a lot of high-profile people got involved in the fight against trying to stop this because it was going through basically limestone cave formations. So there was a concern about a leak would probably immediately affect the water table and people's drinking water and things like that. I think even Willie Nelson was involved in pushing back the Sierra Club. That fight went on for years, and eventually the pipeline company just kept pushing, and it got pushed through and built, and it happened. So really, the effective fight there was going in and saying, I wish this wasn't happening at all. But if it's going to happen to me, I have to be fairly compensated for what I'm losing.
So before we get into the process of what to expect and kind of how to navigate things in the best way, if this is happening to you, what types of public uses enable eminent domain to happen? What are we usually looking at besides pipelines, for instance?
Right. So the classic example, especially in Texas, with the huge influx of people in recent years, is roadways. So highways, roads, sometimes new ones being built, but more often it's expansion projects. So a city like Austin, where I'm based, we go all over Texas, but I'm based in Austin. We'll say we have so many people coming in, we have so many more cars and traffic, we need to expand the roadway, we need to widen, do this, that, and the other, and all the things that go along with that, which means moving existing power lines or setting up drainage and all those kind of good things. So roadways is a classic example, and I think most people would agree, well, it's definitely a government function and it's necessary. I wish it wasn't hitting me, but the ones that get kind of interesting along those lines, there'd be sewer line or even drinking water projects. The one that really gives a lot of landowners heartburn, though, are where a private company, or maybe, it can be a power project, which you could say, well, okay, that's going to benefit the public. It might not be me directly, but somebody down the line, I could maybe see that. But when a private company, like an oil and gas company, says we need a new line to push through natural gas or liquid petroleum products from one part of maybe far east Texas to far west Texas. And they, by following the proper procedures, they are able to essentially borrow the power of the government, the eminent domain authority of the state of Texas, to use eminent domain to say, we're coming across your property and you can't stop us. What most people have a problem with that is that it is private enterprise.
Yeah.
And that company,
back to my Constitution over here, my friend, I said you can take it for public use. So now we're talking private interest. Talk to me a little bit more.
That's right. Well, the oil and gas company goes to the Texas Railroad Commission, which is in charge of the oil and gas permitting process for these kind of pipelines. And, I like to joke that the Railroad Commission never met a pipeline they didn't like. They crisscross the state. If you go up in a plane over Texas, you will see the scars that oil and gas pipelines crisscross the entire state. And there's more coming, and they're being expanded and things like that. So what most landowners get really upset about is that by design, these companies are planning on making a profit. Maybe millions and millions of dollars once this becomes operational. And it's like, well, how is that really public? It's a private company doing a for-profit venture, but the reasoning that is given is that people need natural gas to heat their homes and whatever, and so we have to provide it. And yes, we're going to make a profit along the way, but a lot of landowners are not crazy about that.
I can see why. Yeah, but yeah, you can see both sides of it at the same time. Okay, so where does the process start? How do I know if my land is, on the hit list?
Well, some people will get a notice that maybe there's going to be a public meeting about a proposed pipeline, for example, and they can contact the company who's going to be doing it or their right-of-way representatives and find out more information. Sometimes there'll be public meetings where they can attend and ask those questions, or they can find out directly. Some people don't find out it's coming until they get perhaps contacted getting with a request permission to survey. They want to come onto your property and survey the property and figure out where they want to run the line and what's there that they're going to have to deal with if they run the line through the property. So sometimes that's how people find out, with a phone call and or maybe a letter from the project. Sometimes they find out from us because we do mail out to landowners when we find out about project, just giving them a heads up that, hey, be aware of this and let us know if you need help with that. But the one thing that if you're going to get hit, if you kind of draw the short straw and you're going to get hit on this, under the Texas Property Code, which sort of governs how all this is supposed to work, you have to receive a formal offer packet. And that will contain a number that they want to pay you. At some point, they'll generally provide you with an appraisal. It says, here's how we came up with that number. And that's when you really know they're coming, because there'll be a survey on there that shows where it's going to hit you and what it's going to look like and what they're trying to pay you.
And so how do they know so much about your property? Have they already come onto the property and checked things out? Or how have they now gone to an offer already without much back and forth?
Right. Well, they have a general idea with the engineering they do ahead of time of where they want the line to run. For example, if it's a roadway, it's where the road is and how do they need to expand it. For oil and gas, they will say, here's where we need to run it for engineering purposes, for efficiency purposes, for cost savings to us. What's the cheapest way to get this thing built? And a lot of times it'll be through rural areas as much as they can, because those properties are more wide open. They're generally less expensive than something that's been commercially developed. So they want to avoid having to pay to go through those areas. And they can find out based on their engineering who owns these properties. And we find out the same way. When we find out about a project, we can figure out which landowners are going to be hit by that. And those are the people. And then with title search, the company is supposed to find out who actually has title of this property, who needs to receive notice of what's going on here.
Right. Okay. So I've got my packet and I'm going, okay, this is happening. I've checked my Constitution. They can do this. And so what am I going to do next? Just go ahead and take the offer?
Some people do. And the problem with that, and of course, every case is different. Every property is different. But the problem with that is oftentimes the offer is very low and does not take into account a lot of things that need to be taken into account to compensate you. But the analogy I draw is sometimes, let's say you're in a car wreck. The insurance company has a lot of car wreck claims. They will make generally lowball offers to a lot of folks, knowing that a number of them will take it because they don't have time to deal with it. They're afraid of the process. They're nervous about what's going to happen to them if they don't take it. And I think people have the same attitude a lot of times about eminent domain. Most people have never been through it before. So it's scary when the government or a large corporation says, we're coming through, we have the right to do this, and here's what we're going to pay you. Some people think they have to take it.
Right.
They don't. It's the first step in the process, but some people do accept it, and that's what they get paid, and the project comes through.
So if you think, oh my gosh, I need to at least investigate this, or this could be a low ball offer, what do people do next? Is that when you immediately hire a lawyer, or can you go talk to the company, try to negotiate it yourself? What are best practices there?
You can negotiate it yourself, and it depends. I think of course, you're the landowner. It's entirely up to you what you want to do. If you have if you're, let's say, a developer or a land investor and you have really deep knowledge of the value of your property and you're willing to do a little research about eminent domain and figure out what elements ought to be in my compensation. So just to back up a little bit, there's 3 elements to the compensation that need to be considered. One is the take. So what is the dirt worth that they're going to take from you? Okay. Whether it's the strip the actual pipeline goes on or the portion for the road or whatever it is. And that's usually a comparable sales or comps battle. It depends. There's different ways of valuing that, but a lot of times that's what that is. Like, what is the property really worth? And there's usually a fight there about that. The second thing is what's called cost to cure damages. So what is going to be broken or removed that has to be repaired or replaced? And in rural areas, that can be fences, cattle guards, lighting systems, security. If they're coming through a building that has to be redone or development that has to be changed and moved back, all of those things can factor in. Then the third thing is what's called remainder damages to the remainder. So the property you have before and after the project you still own, what does it do to the value of that property because that project has been done? You might have problems developing it. You might have problems with people saying, I don't want to buy a property that has an oil and gas pipeline running across the middle of it. I want to buy one that doesn't have one. And it affects the value of the remaining property. And a lot of times that can be the largest number in the damages depending on what's happening.
Right. And what about in the case where, okay, maybe the pipeline or road or whatever it is isn't coming through my property or even right next to it or anything like that, but I'm just, an eighth of a mile away or something, surely that's going to have an impact on the value of my property, even though it's not being taken.
It does. And that is a huge problem. So it's kind of like, nothing against pig farmers, but if you're downwind from a giant pig farm that goes in, there's going to be an effect on your property and sort of your standard of living, right? And particularly the modern equivalent of that. So in oil and gas pipelines, you might have a pressurized pumping station put in on somebody's property that keeps the pressure up in the line so that the liquid petroleum and everything keeps moving. Those, apart from being above the ground and visible and ugly to most people, can also be pretty noisy, right? And there may be lights and things associated with the area that they install, all these things that they put above ground. One thing that people are running into now is things like data centers. So you can have these data centers that have these huge cooling units to keep all the servers and things cool that can be really, really loud. But they weren't part of the negotiation for this property. And that may have been a private purchase from a company. But it is something. Now, there is such a thing as inverse condemnation. So it's a little bit different animal. Let's say, for example, they come and change the roadway near your farm. And because they didn't do the drainage right, now where you used to always be able to farm there, you get flooded every time it rains and it destroys your crop. You can go and make a legal claim that you effectively taken my property and damaged my property, even though you weren't actually taking my property originally. Now, inverse condemnation is complicated, and you become the plaintiff where you have to kind of push the ball forward, and it can be expensive and lengthy. So it's not a great thing, but sometimes it's your only option. Yeah.
And in this situation where you're a little bit away from the actual taking and you're not negotiating it and your value is impacted, there's really no recourse. That's just that's tough. Life's not fair.
Unless you have a valid inverse condemnation claim, sometimes that is the only that is the result, and it's bad, especially if you're somebody that either because you have to be there because you use the land, for example, for your livelihood or your business somehow, whether it's agriculture, whether it's another kind of business, or maybe you move to that place because that's where you wanted to live, quality of life issues, and that really, those are the toughest ones because that is a really much more emotionally charged type case than, let's say, this was an investment property that I wanted to develop and now I'm going to have to change my development plans. But that's a little different from I live here, my grandfather and grandmother lived here, I want to give it to my kids, and look what they put in next door.
Right, right. You mentioned data centers. Have you seen anything moving in the direction of, data centers in the context of AI? And we hear so much around how much land they're taking and how much water it's taking and all this stuff. Do you see things moving in a direction where data centers for AI purposes are going to be, have the rights that a pipeline has? They're private interests, and it's not really a necessity, like heating a home, having access to ChatGPT, to me is not quite the same. But is that where we're headed with data centers?
Yeah.
Do you have a ton of job security coming your way?
I don't. I feel like my job security may be just because so many people are moving to Texas and it's growing so fast. But and I am by no means an expert on where the whole AI thing, data center thing is or is headed. I have not seen that, but I can see that argument being made that, look, this has become a access to high-speed internet and/or artificial intelligence type services becomes a utility effectively. And people need water, they need power, and now they need their internet and their AI, and we have the right to. I haven't seen it yet. I guess it's possible.
But it doesn't seem too far.
It sounds kind of nightmarish to me, but I wouldn't put it past them to give it a shot.
Well, and what the heck with the Google fiber? Nothing against Google fiber, but you see these yards torn up. It's going in. Is that eminent domain? Do they have to pay the houses to redo their landscaping and all of that stuff, or what's going on there? How does that tie in?
Funny you should say that, because that's actually happened on like houses on either side of where I live recently. And I was kind of like anybody. I was like, wow, I'm glad I didn't get hit. I didn't draw the short straw. But most of those that I have seen, most people may not realize that where they live, for example, in a city, there's usually around their house a fairly large easement that doesn't actually belong to them. Like next to the street, there'll be an easement for the city to do utilities and do things like that. Now, it gets tricky because you're right. Like the ones I've seen have been, Google Fiber coming in, but they're doing it in from what I can tell, they're doing it in the city's easement, even though it's like it's your yard where you mow and you have a tree there that you really love and everything. But sometimes you don't realize, like, we don't actually own all the way to the street.
Right.
So from what I can tell on most of these, it looks like they're using within the city's easement, and obviously to come to some kind of arrangement with the city to do that.
Yeah.
To provide it, like like we were talking about, almost like, well, it's a utility. It's high-speed internet. Everybody's going to love it, but we got to put a giant hole in this guy's yard and sink this huge box in to put the wiring in. So
crazy. Yeah. And so that's what, that's why
you don't have to mow it anymore, but that's about the old.
Well, there's that. Yeah. And so that's why when buying a house, certainly you need to pay attention to that survey that no one ever really checks out, because there's a lot that could happen. What are you buying?
Poles and things, out in front of your house. I mean, the power lines rather, or phone lines or whatever. You look at that and most people don't think about, well, like, wait, is that running across my property? And it's not. It's usually on the easement for the city or wherever you're living that allows that.
Right.
And you need power, but you may not realize, like, I don't really own everything underneath where they did that.
Exactly. Okay, let's get back to the process of eminent domain that you were starting. And so I've got my packet, I've got my offer. I'm not real happy about the offer, not real happy about any of this. I call David Todd or someone similar. What happens next? What's the process? What are you going to tell me?
Well, what I'm going to tell you is that, first of all, they might try to throw you an offer that does very minimal kind of support to it. And by that, I mean, they haven't done an appraisal yet. And when I get involved in the case, I'm always insistent, like, we're really not going to do much until they give us an appraisal, because even though we may not agree with their appraisal at all, we need to know where they're coming from. and what they're using to try to give you this offer, which a lot of times is kind of a ridiculous offer, but we need to know where that's coming from. It also gives us a lot of specifics about the project itself, like what is exactly, where are they crossing your property? Where is this going to happen? So that's the first thing I tell people. Now, the second part of this is you can negotiate a settlement at this phase. Most of the cases that I get involved in, we don't. And the reason for that basically is it's hard to get a good result this early in the process, meaning full compensation in our experience. So what happens next is if you don't work something out, and of course, I'm biased, I think you get a better result, a net result that's better if you're represented, and also you bring in appropriate experts as needed, which we'll get into in a minute. As you do this process, and you have to be willing to take your time and do the work with your, in our case, with our landowner client to make sure we're doing everything to be ready to push for full value. So the next step is if they don't work something out, eventually they'll file a condemnation lawsuit. So condemnation is basically the legal process where the government or whoever is using eminent domain authority enforces that authority. It pushes forward using the legal system. That's the condemnation process.
So eminent domain is the right. Condemnation is the enforcing it, the process.
It's the process. That's right.
And when you say they file a lawsuit, who's they? Is it the landowner because they want more money, or the business?
No, it's the condemning authority or condemnor. So what that means is, for example, the company building the pipeline.
Okay.
Or the state of Texas, through Texas Department of Transportation, they want to widen a roadway. They'll be the plaintiff filing a lawsuit, and you're the landowner. You receive a lawsuit. You get served. And if you represent it, your lawyer gets a copy as well. And it's like, wow, I'm in a civil lawsuit. They're suing me to enforce the domain. Yeah.
Yeah.
So you're now the defendant in a civil lawsuit, like in any civil suit, which is great fun. You're really glad about this property. That's what I wanted to do.
Exactly. And paid so much for it.
But
because land is most. No, I was just going to say that because your property, I mean, just to drive this home, is most people's biggest asset.
Yes.
And this is being threatened, and now you're being sued.
Yep.
Because they want to take your property from you. But that's where the lawyer and attorney and counselor comes in. I'm sure.
It's hard not to feel a little violated when that happens, because you're like,
no kidding.
Getting sued because they're demanding my property.
Exactly.
So the next step in the process, and this is all through the Texas Property Code, this is required. As soon as the lawsuit gets filed, it goes to what's called a special commissioners, gets set to go to special commissioners hearing. So the commissioners are appointed by the judge whose case the case landed in. So it gets filed, let's say, in a county court in whatever county where the property is. It's always in the county where the property is located. And they appoint commissioners. There'll be 3 commissioners, usually with a couple of alternate commissioners in case somebody objects to one of the commissioners. They're usually real estate experienced types, maybe lawyers, maybe realtors, maybe brokers. They usually have some previous relationship with the court, maybe doing this before, those kind of things. They get appointed to listen to not just your case, but all these cases for this particular project. And then what happens is you have a little mini trial at some point, a special commissioner's hearing. But what happens is they set it for a special commissioner's hearing, and you go in and have an administrative sort of mini trial. It's not quite as formal as a courtroom trial. The rules of evidence are not really strictly enforced. A lot of stuff comes in as far as evidence that might not come in the courtroom. But both sides present their evidence, and then the commissioners come up with a number, and usually the same day, saying this is what we think is fair compensation to you, the landowner, for what they're about to do to you, or what maybe at that point is really going to happen quickly. And then what's interesting about that is Texas is what's called a quick take state. So what that means is the condemning authority, whoever's building the project, they like to get to the commissioner's hearing, because once a number is determined and they deposit that number, that amount with the court, even if you object to it and you say, I want to continue with litigation about what I ought to be paid, at that point, they have the legal authority to take possession to start construction of the project. So,
wow, as long as they've deposited the commissioner's number with the court.
Now,
okay,
either side has the right to file an objection within a pretty strict time frame. It's basically 20 days to say, I don't like this number. So it could be the condemning authority saying, that number's too high, we're not going to live with that, we're filing an objection. Or it's the landowner saying, that's not enough money, we're filing an objection. And that puts it back in the court to do regular litigation like a regular civil case.
Okay.
So that's what happens there. Now, I have my thoughts after doing this a long time on the commissioner's hearing is the majority of the time, it doesn't make sense for the landowner to go to the commissioner's hearing and fight. Now, there's exceptions to this, but the reasoning being that, one, what I just mentioned, let's say you go hit a home run, which usually means you get awarded your number that your appraiser that you used, your expert on your side said, this is the number. And maybe it's a lot higher than what's being offered, and the commissioners might agree with you. 9 times out of 10, the project builder comes in and files an objection, and you're kind of back to square one. You don't have a resolution yet, and you've spent a lot of time and you've paid money to your expert to get to that point, which is money maybe better spent down the road if you have to go to trial. Also it's a chance for, the other side maybe to try to trip up somebody on the witness stand or whatever and try to use that against them down the road or whatever. So there's a number of good reasons why a lot of times we recommend we might go to the commissioner's hearing maybe to gather some information or ask questions, or we may not go at all and just say, we're going to file our objection and we're going to do this in the courthouse, or we'll settle it before trial.
So you have the option to not go to that hearing.
That's correct.
That's very surprising.
The condemning authority does not have the option to not go to that hearing and get that number because they have to get the permission to proceed to the next phase.
Got it. Okay. So let's say you object to the number, whether you've gone to the hearing or not. Is it straight to trial, or is there yet another bite at the apple to try to settle this?
Well, you always have the chance to settle. And there's a couple of realities on this. The best practice really is you have to take it from day one as if you're going to have to go to trial, which means present it to a jury, hopefully of sympathetic landowners in the county where the property is located that may not be crazy about how this maybe feel a little bit like bullying by the condemning authority, but whatever the case may be, they hopefully will be open to your arguments about compensation. And you have to support those. You can't just make them up out of thin air as far as your numbers and what ought to be compensation. But you go to the regular litigation process. So that means discovery, which means exchange of information, maybe depositions under oath on both sides. And then eventually they're going to make you go to what's called mediation before you get a trial. Mediation is where you have a neutral third party that tries to help you come to a settlement agreement. A lot of times it works. Probably 9 times out of 10, a case will settle at mediation or maybe after mediation before trial. But pretty much across the state, they're going to make you at least try mediation before they'll let you have a trial.
Okay. So we all know how expensive and time-consuming and emotionally draining trial can be. Given your experience, where do you see things settling or coming to a resolution along this timeline that you just talked about, from when you get your packet and have the opportunity to engage yourself, and negotiate, and then you've got the commissioner's hearing, then you've got mediation, and then you've got trial? Where do you see most things resolving themselves?
I would say the majority of these, the ones that we get involved in, most of them are after the commissioner's hearing, because usually you can't get a good result short of that. And a lot of times it's at mediation, but that's usually after you've done trial prep work and you probably have your trial date ready. You know when you're going to go to trial. Like I said, you do have to have the approach that you're always ready, willing, and able to go to trial if you need to, because that's your ultimate leverage, is that, you'll take it to a jury and hope that they do the right thing if the condemning authority won't do that. Now, one thing I didn't really get into that I probably should mention is we will generally, in my firm, we won't do a case unless the landowner is on board that we're going to have to hire, meaning the landowner is going to have to hire at least an appraiser for our side of the case. And we connect them with appraisers we like to work with, understand condemnation. It's kind of a different animal from like, I need an appraiser to sell my house. And get that because it's a partial take and there's some different nuances to it. But you really, to have a chance of getting good compensation, you need that expert on your side because they have, on the other side, they're going to have an appraiser always. They're going to have a project engineer sometimes. They may have a cost estimator for cost to cure issues and things like that. So we're always going to need an appraiser on our side. And depending on what it is, if it's like a commercial development, a lot of times we have to use a land planner expert that says, this is what this project's going to do to the project they're trying to build here, meaning the landowner's trying to build. And here's how it's going to cost them and hurt them because they're taking away this big chunk of property. So you have to have experts on your side, and those experts can be pricey, but what we found is usually it is a really good investment because of the return you normally get at the end of the day can oftentimes be many multiples of what you spent to have those experts. But you have to be willing to invest that into your case, in my opinion, to have it getting a good outcome.
Gotcha. And speaking of fees, you do all this for free. Is that right?
Well,
out of the goodness of your heart.
What we do at our firm, we do it on a contingency. So,
of course,
whatever, right? Whatever the first number is that you get offered as a landowner by the project builder, when we do an agreement, we put that in there and say, all right, that is the floor. We don't take any part of that amount. Okay, because that's already been offered. We didn't do anything to get you that. They offered you that. What we do is we charge a third of what we get the landowner beyond that number, above.
Over and above.
Yeah, so it's a third of the extra. Then the other thing to think about as a landowner is you are responsible, at least working with us, you're responsible for those fees for the experts. But you generally know, you have a pretty good idea up front what those fees are. In some cases, you know exactly what the fee is. And then you know, like, well, if my appraiser has to come testify at trial, then they charge X per hour or things like that. So you can sort of plan for that. But we only, in my opinion, it's only fair that we get paid based on results. And I don't think an hourly setup type thing is good for the attorney or the landowner in these type cases. And again, I think it's fair to be based on results, and I think a landowner should not be able to, or should not be unable to get legal help because they don't have an upfront fee to pay the lawyer to bring them on board. So that's why we do it that way. Yeah,
that's a big consideration. You don't have to be out of pocket, and your interest is aligned with theirs, and that the more they can get, the better your fee.
Well, and efficiency works for both us and the landowner. There's no incentive to run up, amount of time you spend on it. If you know where that nail needs to go and you can hammer it in a week, and get a great result, great. Everybody wins.
Right. Well, and speaking of timeline, it sounds like, just depending on where you find yourself on that spectrum of getting it resolved, it could be a matter of months or a matter of years before you see this resolved. Is that right? The further you get, the closer you get to trial, obviously, the longer the process.
Right.
Which can be a few years.
Well, yes, but I will say that probably the average time frame of cases once we get involved that do get resolved short of trial, generally about 9 months from when we get it. If it goes to trial, usually longer. A lot of that has to do just with court availability and scheduling. Sometimes hard to get in quickly with a trial date. Then if you go to trial and somebody has an appellate issue that they need to take up on appeal, obviously that can add to the time frame.
Sure.
But most of them resolve within 9 months, certainly less than a year, if you can do a good enough job where maybe you don't have to end up going to trial.
Yeah. Gotcha. Well, David, this is like not the best news in the world that your property can be taken legally and apparently under our Constitution and everything. But I am glad for people who listen to this and now understand the process and know that they do have rights in all of this. They shouldn't just take what's in the packet necessarily.
Yes.
So thanks for this explanation. Thank you for the work that you do, David, because I do think it's important work. It is the underdog. And it's I keep using underdog because you're such a dog fan.
Well, it's one other thing, Brooke, that I didn't mention is that if anybody is interested in this stuff or has questions or whatever, one thing I would recommend is on our website, davidtoddlaw.com, I did put together a video that will walk you through the condemnation process and also explain how we try to help landowners, et cetera. And I recommend that to landowners that we may never even work with. Because I do think it's important to educate people. If you end up calling me, if you've already watched it, it saves us both a lot of time because it answers some basic questions. And I also think it helps all landowners if everybody is better educated about this. And I think it will improve the outcomes for everybody, not just the people I work with, if they know what's going on and how to sort of, what questions to ask, how to protect themselves in this process. So I would recommend watching that video on our website.
Right. We'll put that in the show notes and everything. Make sure people can go to that. Knowledge is power.
There you go.
And what? Life is legal. So you got to know the rule.
Awesome.
All right. Well, thank you so much for spending time with us today, David, and appreciate all of your knowledge on this topic.
Thank you, Brooke. It's been great.
All right. See you later. Thanks again.
Bye-bye.